Good morning, everyone. My name is Steve Buckley. I'm Legal Services Counsel for the New Hampshire Municipal Association, and this is a presentation I've given many times, improved and changed and updated over the years, really trying to give those who are in planning boards and staff basic introduction to the ways and means of being a planning board member and planning board activities. This is what I'm going to cover today. One of the things that apply to planning boards from the cases that were mentioned by Stephanie is the duty to assist those who are participating and submitting applications to your land use board. I'm also going to address conflicts of interest. Then I'm going to spend some time addressing statutory duties, all of the specific statutory duties that are found in the RSAs, the subdivision and site plan regulations and regulatory activities related to those primary functions of the planning board: master planning, workforce housing, capital improvement plans, zoning amendments, etc., listed here on the slide. Then I'm going to address preliminary review, applications, the timeline for review, third-party consultants, specifically address some of the important changes that were brought about due to HB 1661, which was adopted last year, and then address public hearings, making the decision, conditional approvals, vesting, and finally appeals to the Housing Appeals Board and the Superior Court. So let me start with the duty to assist, because I think this does speak as an important obligation that planning boards have in its relation with those who are submitting applications to you. And generally speaking, the Supreme Court has identified in the Richmond versus City of Concord case that planning boards must act reasonably in applying statutory and municipal regulations to each application. And so what we emphasize here is that planning board members and staff must be mindful of the expense incurred by those who are seeking approvals from your board, and be careful not to make representations that may mislead a developer or an applicant. And generally speaking, boards should not be in the practice of granting preliminary approval arbitrarily. So you got to give a preliminary approval and then believe that they are free to reject the application for final approval. I think you should be using preliminary approval in terms of the duty to assist to move the project down the road eventually towards approval based upon your rules and regulations and your zoning ordinance. And one of the things that the court said in that case and related cases is that municipal officials must be free to advise applicants on whether their applications conform to the statutory requirements and make suggestions on how to bring the application into compliance. If an application does not conform and will not be accepted, the official should be able to communicate that information without being accused of prejudging the application. So the application, the subdivision and site plan process is not intended to be completely adversarial. And so advising applicants how to work out and negotiate the final permit process is really part of the duty every planning board member has and the planning board as a whole. A few things about conflicts of interest. There's two important elements of this statute, RSA 673:14, that merit your attention. So there's two parts to it, but the first part addresses when a land use board is acting in a quasi-judicial capacity or judicial capacity. So just understand what that means. When you are taking jurisdiction by accepting a plan as completed, and then you're going to be receiving evidence from the applicant, concerned abutters, and other members of the community, you are collecting evidence from two sides, potentially, of a point of view concerning a particular application, and that's inherently defining your acting in a judge-like capacity. So whenever you're doing that, acting with regards to a proposed subdivision or site plan with abutters and applicants presenting issues and questions to you, that obligation to act in a judicial capacity imposes the duty to avoid circumstances on a particular application where you have a personal or pecuniary interest in the outcome. And that basically means if you're an abutter or if the applicant is a relative, those would be per se reasons why you would need to recuse yourself from that particular application. But then the statute also goes on to say you also have to take into account circumstances where, if you were acting as a potential juror in a case that was going to be heard in the Superior Court, you take into account the court's use of various questions that potential jurors have to address before they can be made part of a jury to consider a matter in the Superior Court. And these are the questions. If you've been ever called to sit on a jury, these are the things the Superior Court judge will ask you. Do you expect to gain or lose? Are you related to any party in the matter? Have you advised or assisted any party? Have you directly given your opinion? Have you formed an opinion? Are you employed by or employ any of the parties in the case? Are you prejudiced to any degree? And do you employ any of the counsel if there are lawyers appearing before your planning board in the pending action? And those would be another reason why you should reconsider your participation and potentially recuse yourself.
Hey, Steve, excuse me. We have a quick question on point. A question is, how come the conflict bar doesn't apply to BOS?
Because this is we're presenting an issue on planning boards. So the Board of Selectmen would have, in certain circumstances, the duty to avoid conflicts of interest when they are acting in a quasi-judicial capacity, which is generally a rare circumstance. So it's a whole different set of circumstances where a select board might be acting in a quasi-judicial capacity, but generally they're not. So, but again, we're talking about the planning board today, not the Board of Selectmen. And if you have questions about select board matters, one of the big jobs that I have at NHMA is to answer inquiries, the legal inquiry service, and we'll have our contact information at the end of this presentation.
Okay, thank you very much.
I do want to mention this one case, which I think is really illustrative of the duties that planning board members have when acting in a quasi-judicial capacity to avoid prejudgment. And it also speaks to the issues that are endemic these days with the use of social media in many different communities. Social media has become one of the more common ways in which citizens communicate with each other and communicate with local government. And so I just want to explain the background of this case and indicate to you there are some important lessons to be learned what happened in the Z1 case, which, by the way, this very application is still pending as an additional supplemental issue going on in the neighborhood where this gas station was eventually built. So this was a conditional use permit application where the planning board in Manchester was asked to approve a proposed gas station in and near a residential neighborhood that got the residents up in arms. And so it was a contentious series of public hearings and presentations. There was a strong abutters group that were opposed to it. But after the final public hearing portion, the planning board had closed the public hearing, but before the board commenced deliberation, two members of the planning board voiced opposition to the project. This is before they voted on the social media site established by the residents opposing the project. And one of the members who voiced that opposition to the project before he even voted whether to approve or disapprove was asked to recuse himself at a hearing where the board was the planning board was considering that very issue. And he refused, and he later voted to deny the application. Well, of course, it gets to the Superior Court, and the Superior Court looks at the issue and concludes that the members' failure to enter into and participate in deliberations with an open mind threatened the integrity of the deliberative process and undermined the trust in the overall function of the planning board. The case was reversed. It was sent back to the planning board. The planning board ultimately approved the project. So two things I would say, well, probably the most important thing to say about social media activities in your community. Stay off social media. Don't comment on social media if you're a planning board member, especially if it's related to a pending land use board matter that's happening in your community.
Steve, another quick on-point question, if I could jump in. What if a relative works for the party in the case? Should they recuse or not?
Well, I guess I would say this. It really depends upon the importance of the relationship. And there is one case that gives us guidance on that particular issue. It involves a situation in the Rockingham County. So in the particular case, I can't remember the name of the case off the top of my head. We had a situation where the county of Rockingham had applied to, I think it was the planning board in Brentwood, because the county owned land in Brentwood that they were going to turn or modify the design or increase the size of the local nursing home. And although the nursing home, technically, I think they were exempt from zoning, nevertheless, they went to the planning board for approval, the Brentwood Planning Board. And they were seeking permission. And it just so happened that a person who worked for the county of Rockingham was on the Brentwood Planning Board. But he worked in an area totally unrelated to nursing home administration and management. And so the degree of unrelatedness of that person's employment to the matter at hand indicated that there was no conflict of interest. However, if the relative who works for, I mean, if let's assume that if the relative works for Walmart, and Walmart is before the planning board, but the person works for Walmart in Florida, and there's no relationship between what the relative does in Walmart, in Florida for Walmart, to the activity going on in a New Hampshire planning board, you'd probably say that's not going to have an impact on my decision making. On the other hand, and that's the beauty of this slide, you have options. If you have any doubt about the necessity of recusing yourself, just recuse yourself. Hopefully, your board has enough alternates to step in to take care of the matter. The other thing you can do as a planning board member, you can ask your fellow planning board members for an advisory vote. What think you, members? This is the situation. The applicant here is the employer of my brother-in-law, and then explain the circumstances and get their input. So the safety of decision-making is probably one where you would conclude, I'm not going to risk putting the issue in the decision making in jeopardy. I'll just recuse myself. So recuse, and ultimately the issue should be you're not abstaining. I would again emphasize avoid social media opinions on pending matters. I personally don't have any social media contacts. I'm on the ZBA in my town, and I know there's some ZBA activity questions on some town Facebook page, and I never look at it, and I don't care to look at it. But you should, when necessary, disclose your conflicts and remove yourself, and generally speaking, err on the side of caution. So let's jump into the whole array, the significant array of statutory duties of planning boards. So the planning board does a great deal. Its job is to do your master plan. In many communities, the planning board does the capital improvements program, the CIP, although many towns have switched to a separate method, just so those of you have a capital improvement plan, many communities do, of course, it's very appropriate. Many communities have switched to a CIP committee, which is appointed by the select board rather than having the planning board do it. But many towns still have the CIP as something that's a planning board function. The planning board, very significantly, is one of the agencies in town that recommends zoning amendments. And it also is the agency in towns that proposed the first zoning ordinance. Of course, the planning board is involved with subdivision regulation, site plan regulation. Your planning board may also do excavation regulations. If I'm not mistaken, the default setting in the statute is that the planning board is the excavation regulator, but it can be delegated by town meeting to the ZBA or the select board. And then the planning board has power over driveway regulations, but typically it's a divided authority between the select board and the planning board to have driveway regulations. So it's a broad array of statutory duties. Two things about subdivision and site plan approval. The first of these is, and this is true for subdivision and site plan, requiring preliminary review of subdivisions. The planning board can be given the authority by town meeting to require that every application, whether it's a subdivision or a site plan, get conceptual consultation. And there's a great beauty in conceptual consultation because you can have the applicant come in with broad sketch plans of what they're planning to do, and you can have an interactive discussion with the applicant, which is not binding on the planning board, and it's not binding on the applicant, but you can get a better feel for what the project is going to be. You can discuss how they're going to proceed step by step. And so I was encouraged to make sure your regulations have a provision, which has to be delegated to you by town meeting, that you can require preliminary review of subdivisions and site plans. It's a very worthwhile authority to have. Of course, under subdivision, you're approving plats and plans. Most importantly, you're approving plats and plans that would also include new roads that are going to become public roads in the future. And those roads would be an approval including utility facilities and services. If you are going to have site plan review, you have to have a zoning ordinance. If you don't have a zoning ordinance, a planning board cannot have site plan authority. And the planning board has to have adopted subdivision and site plan regulations to implement site plan review. The planning board's authority there for site plan review is for the development or change or expansion of use. And this is addressed to non-residential uses or multifamily dwellings, that is, structures with two or more dwelling units. The important concept here that I want to emphasize is when a site plan is approved and an applicant wants to change or expand the use, the planning board has jurisdiction over whether that expansion or change would be subject to further site plan approval. I always feel it's important to, at this stage of my presentations, to touch on the workforce housing statute, which was adopted, I'm fairly certain, in 2009. And it was designed to require that workforce housing has to be allowed in a majority of the land areas zoned residential in your community. And honestly speaking, the workforce housing statute is a bit complicated because it uses these very sometimes difficult to quite appreciate definitions of what workforce housing. So the two check marks at the bottom tell you what they are. So for workforce housing, it's defined as a house which is affordable to a household with an income of no more than 100% of the median income for a four-person household for a county in which the housing is located. And for rental housing, it's affordable to a household with an income of no more than 60% of the immediate income of a three-person household for the county in which the housing is located. New Hampshire Housing publishes a table that gives you the data on what those numbers look like in various counties. So that's the place to go to understand what that what those numbers look like in terms of someone comes to you with a workforce housing project and says this is a workforce housing project. You're going to have to make sure they demonstrate the price point, the ultimate price point for the unit of the dwelling unit is going to be consistent with the definition of these definitions of workforce housing in the county where you're particularly located. I just want to quote, however, an important part of the court decision that preceded the workforce housing statute, and it's what the court said. And this is in the Chester Britain versus Chester case. A municipality's power to zone property is to promote the health, safety, and general welfare of the community is delegated to it by the state, and the municipality must therefore exercise its power in conformance with the enabling legislation. And what the court found that because the Chester zoning ordinance does not provide for the lawful needs of the community, it flies in the face of the general welfare provision of the statute 674-16, and that's because it was found by the court that the town of Chester did not adequately supply the availability of housing to be built for all income levels of those who live in their community. And consequently, the Chester zoning ordinance is thrown out as being inconsistent with the duties that are found in how zoning has to be adopted in New Hampshire. So I guess probably, and this is a very important topic which is currently going on, the regional planning commissions in the state of New Hampshire have done housing needs assessments, brand new housing needs assessments, and ultimately the question that has to be addressed by planning boards and all planners in every community: does your municipality have its fair share of workforce housing? Are you accepting your fair share of workforce housing for the needs of those who work within your region? And typically the region of a town is defined by the towns that immediately abut your community and those that abut those communities. And that's typically how one defines what's the region when you're looking at your duties under the workforce housing statute. So I've mentioned the Capital Improvement Planning Program, the CIP. It is an aid with budgeting decisions. So when we talk about a CIP is not a binding document that compels the select board or the budget committee or the town meeting to appropriate dollars which are recommended as needed for the future acquisition of capital infrastructure, whether it's equipment or buildings. It is just something to inform those budget decision makers what's appropriate to ensure your capital infrastructure is maintained up to date and consistent with meeting the needs of those in your community. It is not something that can be used to deny subdivision approval, but it is a prerequisite if your community wants to have impact fees. You have to have a CIP program, and it would also be a prerequisite if for some reason your community wanted to have growth management. I've touched on the planning board's power to propose zoning amendments. Not a very insignificant authority of the planning board is the ability to propose amendments to your zoning ordinance, historic district ordinance, or building codes. And these are ordinances, of course, which are adopted by the town meeting. So just like a select board has a very powerful authority to put the agenda together for your town meeting, which is called the warrant, the planning board has that power. I would also point out there are two other authorities or agencies, so to speak, in your community who can propose zoning amendments. The select board also has the power to propose zoning amendments, and of course, citizens have the power to propose zoning amendments by petition. And of course, very important with regards to the process of the zoning amendment submission to adoption by or approval or rejection by town meeting, that no such ordinance can be established or amended until after the planning board has held a public hearing. And there's your duty to hold those public hearings and give notice to the public does attach to and requires that step, of course, before it can be the proposed zoning amendment could be sent to the town clerk to be included on the zoning ballot. I would just point out that those of you who have, many of you I'm sure, participated in zoning amendment procedures, there's a separate notice statute that does in certain circumstances require the planning board to send separate first-class mail notice to people in a district that are going to be affected by a proposed zoning amendment. So please be sure to check out that provision so that you ensure that additional and supplemental form of notice is satisfied by the planning board when you're considering zoning amendments. Along the lines of the decision making,
excuse me.
Yep.
We have one quick question regarding zoning amendments. The question
Yes.
from Eric is, do zoning amendments need to be approved by official ballot?
Let me just say a few things about the word official ballot. The term official ballot means that your community has adopted what's known as the Australian ballot. So it used to be back in the 19th century, ballots were prepared by the competing political parties. That was eliminated, and most towns have adopted what's known as the official ballot, where the ballot is prepared by government, and then you go to the polling place, and there's a standard form of ballot, typically also prepared with the assistance of the Secretary of State for voting on zoning amendments. So where your town has the official ballot, and you know you have the official ballot because on the second Tuesday of March or the second Tuesday of May, or if you're an SB2 town, it'd be the second Tuesday of March, April, and May, you go to a polling place where you handed a ballot and you fill out your yes, no on that ballot. That's called the official ballot. And so the statute for adoption of zoning amendments is very, very clear that where a town has an official ballot, the zoning amendments are voted on the official ballot, and it's done on the town meeting day, second Tuesday of March, second Tuesday of April, or the second Tuesday of May. However, there are some communities that have not adopted the official ballot. And so in those communities, what happens is all the activities at town meeting take place on the floor of the town meeting. People actually get proposed as those who would be officials, and they are nominated from the floor, and then there's a ballot created by the town clerk to elect those officials. The same thing would happen with zoning amendments. The town clerk would prepare a separate ballot that is used to vote by secret ballot on the floor of the town meeting. So back to zoning amendments, I've got here on the slide innovative land use controls. This is a way in which your community can decide to delegate zoning authority to the planning board. I think this is the more common approach, where it makes sense to give the planning board authority to make decisions much like decisions that the ZBA makes when the ZBA rules on special exceptions. You can allow certain uses of land. The ZBA would do it with a special exception. The planning board would do it through a conditional use permit process, where you would approve a use so long as certain conditions are satisfied. So the innovative land use control statute is a wonderful way where the planning board can combine activities, the ones that I can speak to, which was common in southern New Hampshire, the development of a conditional use process for approval of cell towers. And in many ways, that was a smart move by planning boards because it allowed the planning board to combine into one process the approval of the use. Is this an appropriate location for the cell tower? And also to do site plan review, do the commercial site plan reviewing process for that particular cell tower. So I think it's a very useful tool, but there are a number of other things which are described in the innovative land use controls: timing incentives, phase developments, intensity and use incentives, transfer development rights, planned unit developments, cluster developments, impact zoning, performance standards, flexible and discretionary zoning, and environmental characteristic zoning. So there's an array of additional pieces of authority which are described in the statute. If a town adopts an innovative land use control, it should be supported by a reference to the supporting information in your master plan. The administration of the ordinance can be granted to the planning board and ZBA or other such person as the board or as the town determines. However, even if for some reason the ZBA is given conditional use authority, conditional land use authority, which is typically more like a special exception, but it could be adopted in 674:21. They would have to at least consult with the planning board on the decision making if it's not delegated to the planning board. So a few words about the important function the planning board has with regards to public streets. And it's indicative of the fact that there's a cooperative relationship that would probably exist or should exist between the select board that is principally in charge of managing the public streets in your community and the planning board, which is involved in perhaps approving proposed streets that might become owned by the public through the layout and road acceptance process. So the planning board has the power to approve subdivision roads. The planning board has the power to approve site plan roads. The planning board can and should, in its regulation, establish road construction standards. And ideally, those road construction standards should be consistent with the road construction standards the select board has for managing, maintaining, and constructing town roads, class 5 roads and class 6 roads, and also could include class 4 roads. The planning board also has the power to establish the minimum completion of a road before a house on that road can be occupied. It may not have happened as much recently because it's my understanding the cost of building a linear foot of a public road has really ballooned over the last couple of years. And not too long ago, the basic rule of thumb was the cost for building a linear foot of public road was $200 a linear foot. I think that number is more like $500 a linear foot. So it's an expensive process. But to the extent your subdivision, you've approved a subdivision with 10 houses on it and a road length in front of those houses, you can require that the amount of completeness of that road is up to a certain standard before a CO is issued. Many times, towns will allow a project to be built without the final course of bituminous being laid down because during the construction process, all the heavy equipment might damage the final layer of bituminous. But we then say, okay, we're going to make sure you put the final layer down when the final CO is issued. So obviously the road is not totally complete, but you can decide what is the level of completeness sufficient to permit issuance of a building permit. And of course, it's the planning board's duty to ensure if a new proposed road is part of an approval for a subdivision, you set the performance bonding. And a few words about performance bonding. I know there's been some legislation being debated on that subject this year. Most of the back in the day, what was the common way to give security for building a road was a letter of credit. Those are not as used as often these days. Typically, you're looking at a surety bond provided by an insurance company, typically an insurance company that's AAA rated, and you know that it's there to pay for the completion of the road if the developer fails to do the job that they agreed to do as part of the subdivision approval. I mentioned previously driveways. So both the planning board or the select board are authorized to approve driveway permits on town roads, which is an important function which parallels the same function under the same statute that is exercised by the Department of Transportation for driveway access to state highways. But in order to regulate driveways and driveway entrances onto town roads, which would be class 4, class 5, or class 6. By the way, class 6 roads are still town roads. And so the town still has the authority to require driveway permits for access to class 6 roads. You must adopt driveway regulations. And in most communities, perhaps the planning board adopts the regulations, maybe in consultation with the select board, but then they're typically, those regulations delegate permit issuance and enforcement to the public works director or the road agent. And one of the things that's interesting about the driveway statute is the town has continuing jurisdiction over any driveway, even if no permit had been issued for this driveway. So if you have a driveway which is causing problems due to erosion, due to runoff, due to siltation, and the town never had issued a driveway permit for that road, for that driveway, the town still has jurisdiction to order the property owner to fix the driveway to prevent any hazard to the traveling public due to the operation of that driveway potentially threatening the integrity of that local road. Planning board also can use this statute, which I know that many communities delegate to staff, to allow the merger of two lots that are contiguous, that have had pre-existing approved or subdivided lots or parcels. Let me just say a word about contiguous, because this question has come up a lot. If someone wants to merge lots, they can't merge a lot that's separated by a public street because they're not contiguous. They don't abut each other. The lots have to be on the same side of the road. And the process of doing this does not require a public hearing. There's no survey plat that's required. And notice of the merger has to be endorsed by the planning board and recorded at the registry of deeds, which many planning boards do administratively with staff. Ultimately, I would encourage you to understand that if in each instance any of the lots being merged under a mortgage, you need to get the mortgagee, the lender, to consent to the merger. And so I would not tell you that the town has to take a title search to eliminate the possibility there might be a mortgage on the lot. You need to get an affirmation under oath by the person seeking to merge that these lots are not subject to a mortgage. Although you may know the property is subject to a mortgage because it's reflected as such in your assessing records. And if you know that to be true, you're going to have to not approve that lot merger until you have a piece of paper that is an affirmation by the mortgage lender that they've approved the merger. And typically, I think those affirmations and consents are recorded also with the merger document at the Registry of Deeds.
Excuse me, Steve, a chat that is on point for driveways, maybe.
Okay.
Under what RSA or lawsuit does the town have authority over a pre-existing driveway? You may have answered that, but I just wanted to check because it was on point. Specific to driveways.
So those of you who have this wonderful book at your side, which you should if you're a planning board member, I'll read it to you. It's RSA 236.13. And what it says is, I always have a hard time doing it, so I'm not going to be able to read it specifically, but that language that the planning board has continuing jurisdiction over a road, a driveway where no permit has been issued is found in RSA 236:13, Roman 6. So that's where that specific authority exists. Planning boards also have the power to require or pay people to be obligated to pay for improvements to offsite elements of a project that is an element of a project that has an impact on an adjacent piece of public infrastructure. The infrastructure is not part of the subject property, but is being impacted. So this is called offsite exactions, and it's defined very carefully in RSA, and this is the Innovative Land Use Control Statute, RSA 674:21, Roman 5, small letter J. And so what this idea here by statute allows a planning board to do is to determine in certain circumstances that if someone's putting in a strip mall or a large commercial development and they're putting in a driveway and there's concern there will be adverse traffic impacts for the ingress and egress of traffic into that commercial development, the planning board has the power, even if you don't have an impact fee ordinance, to impose an exaction, to require the developer to pay for the offsite improvement to the local adjacent public road, putting in an XL or decel lane, putting in a traffic light, any things that are deemed necessary. So these are improvements which are necessitated, deemed necessary reasonably under circumstances for a development project located outside the project boundaries. And it is subject to the rational nexus test. So you have to, you can't just say we want a traffic light because it would be a great thing to have. It has to be demonstrated based on traffic engineering principles that, and based on warrants and other things that are used in traffic engineering, that in this particular setting, a traffic light is necessary. And it may even be a shared obligation. The town may have to pay for a part of the cost, but it's necessary to put that in. And so that rational nexus test will determine whether you can require that particular improvement in that particular setting. But this ability to impose an offsite exaction on a subdivision or a site plan is limited to highway, drainage, and sewer and water upgrades. You can't use it for any other purposes. So for instance, you can't say, we need you to contribute to the cost of paying for a new fire truck because this is a project which is going to stretch the resources of the fire department. You certainly cannot do that. I've already talked about preliminary review and conceptual consultation. I want to emphasize it again. Planning boards may mandate preliminary review if authorized by the town meeting under RSA 674:35. And just let's understand what the statute defines preliminary conceptual consultation may be. It's non-binding. No abutter notification is required. It's a general discussion of the type of development, relationship to the master plan, and issues that will arise under local regulations, and govern how the planning board will conduct site visits, et cetera. So I think could be a very fruitful, maybe even freewheeling discussion on a project to help scope it out for the benefit of the planning board and the applicant. So ultimately, making it better understood when the completed application comes before the board for acceptance and public hearing. To be distinguished from design review, even though design review is an option for preliminary review, it's still non-binding, but design review does require a butter notification and published notice. But you're not required to have public hearings. You can identify special studies that may be required, and design review may come with some control of changes to regulations for a certain period of time. I believe it's 12 months after the completion of design review. Just a brief overview of the formal application process under 674:76:4. Most of the issues that arise under the procedures for the planning board, and I'm sure Stephanie will cover this in her presentation, all derive from this very key statute, RSA 676:4. So the first step along the way to move forward with an application is to have it considered complete. And that's a decision which is made based on your regulations. Ideally, and this is how I would suggest to be handled, the staff will work with the applicant, go over the checklist. You have a checklist of items we have to have before we consider the application complete. You may even consider fees and costs of consultant studies that may be required during the review process. And then application acceptance happens at a public meeting with a butter and published notice. So there's some clearly preliminary work was done by staff, or if you're a planning board that does not have staff, you could do this type of review at conceptual consultation. You could have the applicant come in under conceptual consultation, go through the checklist with the applicant, and make sure it's ready for plan acceptance. And conceptual consultation could serve as a vehicle for conducting this process. If you have staff, staff is typically taking care of the application completeness process. So your timeline for decision, and it's much more rigid today, and we'll talk about this in a minute. You have no timeline limit on preliminary consultation. That's why I think it's a really good idea to use preliminary consultation, because you now have 65 days, no more, no less, to make a final decision. And if an application is submitted 21 days before acceptance, it has to be put on the next planning board meeting. You have to notice abutters 10 days before that plan acceptance meeting. And then once it's plan accepted, typically most planning boards will schedule plan acceptance and open public hearing at the same time, with the understanding if you don't accept it, we won't open the public hearing, but if we do accept it, then the public hearing will move immediately into public hearing. Then you have to hold at least one public hearing and make a decision within 65 days of plan acceptance. And within 5 business days of making a decision at a meeting, you have to issue a written decision. A few things I would mention about alternative site plan review and review procedures. First of all, the town meeting has the ability to delegate its site review, authorize the planning board to delegate some site review for minor site plan to an administrative or technically qualified administrators. So you would define minor site plan changes or minor site plan modifications, where this could be done by a committee, and then that committee's decision can be appealed to the planning board and for final approval. The planning board can also, or towns often do, larger communities might establish a technical review group. And the technical review group's job is to advise planning board applicants on their project. This actually came up in a recent case involving Martin versus the City of Rochester. Had to do with the right to know law, but it explained the process in a little bit more detail. This was a committee made up of department heads in the City of Rochester: police, fire, health, planning, sewer, water, public works. They all get together once a month and allow applicants to come in and pitch their projects and try to find out what are the concerns that will be addressed when it gets to the planning board stage. And so the advice then is given to the planning board, but given to the applicant, not to the planning board. The other thing that can be very useful, especially under site plan review, the town meeting or the planning board, if the town meeting hasn't spoken, may establish thresholds based on the size of a project below which site plan review is not necessary. So you might have a regulation that says if someone's adding less than 1,000 square feet of floor space, or no more than a certain number of new parking spaces dealing with impervious soils, you can deem it to be a de minimis change and not require full site plan review or modification of a site plan review. That's a judgment call. Every community addresses it a little bit differently, but it's certainly not necessary that every time someone wants to make some small change to a site plan that was previously approved, they have to come back to the planning board for site plan modification or approval. I always feel it's important to touch on this acceptance vesting statute, because it speaks to the implications of what it means when you say a application is a completed application. Amendments to zoning or planning regulations that are proposed after a project is considered a completed application, and even if adopted, will not apply to an application which has been the subject of legal notice of plan acceptance prior to the first legal notice of any change or amendment. So if the planning board posts a notice on November 1st that we're going to consider application acceptance for a new Walmart in town, and then 15 days later the planning board posts a notice of a zoning amendment, that might make that project more difficult to get approved. That amendment, assuming that the Walmart gets approved as a completed application, would not apply to that project. And that kind of makes sense. We want to allow someone to come in and get approval based on the rules in effect at the time of plan acceptance. This also applies to proposals submitted to a planning board for design review, but then it has to be that the formal application is submitted to the planning board within 12 months of the end of the design review process. So just keep in mind, plan acceptance has this particularly a unique impact on how regulations which are subsequently proposed and adopted by a town meeting will not apply to that particular project. Again, kind of related to what you're doing at the time of plan acceptance is to take into account projects that have developments of regional impact have to be taken into consideration, and then, if necessary, make a judgment that is necessary. It's appropriate, required to notify the abutting affected abutting community and the nearby and the applicable regional planning commission. So development of regional impact would be one where a project could reasonably be expected to have an impact on a neighboring community. And so you would probably try to make that judgment at plan acceptance, but maybe you make it beforehand. You may even do it at conceptual consultation. So if you do it at conceptual consultation, you say, this is going to be a DRI, development of regional impact, you would then deliberately notify at plan acceptance in the first public hearing, the planning board and the affected community. And as the statute says, within 5 days of making that determination, you have to send the minutes of the meeting where you made that decision to the regional planning commission, and preferably also the plans and specifications, and also to the affected community. And then there's a series of obviously subsequent public hearings where the neighboring municipality and the regional planning commission will have the status of abutters, and they then will be able to participate in future proceedings as if they were in a abutter. And there are notification standards in the statutes that define regional developments of regional impact, RSA 36:54 to 58. And there are consequences for not identifying a project of one of regional impact and not giving notice to the regional planning commission and a neighboring community. There was a project arising out of the town of Warner a couple of years ago, where it was not found that a project was of regional impact, and the neighboring community sued the planning board in Warner for failing to give notice to them as under the development of regional impact statute. And the Superior Court, throughout the decision on the project, it was a site plan review, for that failure to comply with the developments of regional impact statute. So it could have potential adverse consequences in terms of ensuring that your decisions are not reversed on appeal to Superior Court. So to touch on some important new changes that are brought about through HB 1661, the first of these, and this comes to the decision-making step in planning board procedures, you are now required under 676:3 to state findings of fact, written findings of fact. And in fact, it's important just to understand what the statute says. The decision shall include specific written findings of fact that support the decision. So that's findings of fact that support an approval or disapproval. But importantly, failure to make specific written findings of fact supporting a disapproval shall be grounds for automatic reversal and remand to the by the Superior Court upon appeal, unless the court determines other factors, warranting the disapproval. So I would just say, and I've been doing this with my ZBA, please try to think about when you're making a decision, are there particular issues or facts that came out to the public hearing process or in the record, which you can cite to in saying why you're going to approve this project or why you're going to disapprove it. And this requirement went into effect on August 23rd of this past year. There was a change to the statute, and I've just emphasized it here, and I'll emphasize it on a couple of slides in a short while. You are limited 65 days to make a decision from the date of plan acceptance. There really is not much wiggle room at all, except there is one little bit of continuing wiggle room, which is good. If at some point during the process, maybe after plan acceptance, you decide this is a project of regional impact, you can stop, make that decision, notify the Regional Planning Commission and the affected municipality, and then you get an additional 30 days to consider developments of regional impact. Now, I'm not recommending that you automatically deem every project one of regional impact to get that additional 30 days, but you are given that additional 30 days in those circumstances where you make a reasoned judgment this is a project of regional impact. So the planning board, as I said, has a duty to approve or disapprove within 65 days. And the statute now says that the planning board does not act on the application within 65 days. The governing body is required, read that word, required, underlined, all bold, to approve the application. If the planning board determines, however, that it can't make a decision within 65 days because it lacks sufficient information, it does have the option of, and the applicant will not consent to an extension, it can deny the application without prejudice, which is an important issue because you might not be able to come back to the planning board if you are denied for reasons and they want to resubmit the same application. So here's an option, but understand you got 65 days unless the applicant extends it, or you can decide not to approve it because you don't have sufficient information.
Steve, quick jump in here for a question on point, just for clarification, please. You say plan acceptance, but to clarify, are you saying acceptance of the application or declaring the application complete for the 65-day timeline?
Plan acceptance is a term of art, and that means we've accepted it as complete. So the term plan acceptance and a completed application, those terms, I suppose, they should be all in one sentence. It always means we've determined at a public meeting it meets our checklist, and therefore we're going to take jurisdiction of this application and move forward. So plan acceptance, a completed application, they're all one kind of united set of terms which start the process and start the time clock. So right. Okay. I suppose if we're going to be absolutely clear, you only accept a completed application at a public hearing with notice to the abutters. And when you do that, you say, Madam Chair, I move that we find this application is complete and we are accepted for consideration by the planning board because it meets our checklist or regulations. That would be typically what you would see in a motion. Perfect.
Okay, great. Thank you for the clarification.
And just to emphasize, you've got 65 days. There used to be the ability to ask for an extension from the select board. That's gone. HB 1661 eliminated the ability to request an extension to act on an application from the governing body. Prior law allowed the planning board to petition the governing body to extend that time for action on the application by 90 days. That change went into effect also on August 23, 2022. I want to just say a few things about public hearing procedures as I get closer to the end of my presentation. And just by the way, Stephanie, if you think there are some questions that I might be able to address if I don't use up what I've got till 10:15, correct?
Yes, that's correct. And yes, the sessions will be probably running a little bit shorter because some of the questions that are coming through the chat are really discussion questions, except the ones that we've been kind of pinging you with. So yes, depending on how much time we have, some of the questions that are in the chat are discussion worthy. Okay. Either for now or for the end of the day.
I think I'm more than able to wrap up in 20 minutes. And if I have extra time, I'll try to answer some questions. How does that sound?
Okay, very good. Thank you. So keep the questions coming, people.
So public hearing procedures, want to emphasize the statute is very clear under RSA 676:4. The planning board should hear from the applicant, obviously, abutters, and others with a direct interest, and others may be permitted by the board. Can we just pull that apart for a second? There's no doubt you have to understand that when an application is submitted, you have to hear from the applicant. It's a matter of due process. They have a right to present their point of view as to why the planning board should approve. Certainly, abutters have a strong interest in the outcome of the subject property being approved or disapproved for a subdivision or a site plan, and others with a direct interest. So what that means is those who are nearby a project that would be significantly or somewhat impacted by a project's offsite effects, traffic, noise, whatever the case may be, those people would have a direct interest. Just remember, just because someone lives in your community and is 5 miles away from a project doesn't necessarily mean they have a direct interest in the outcome. Direct interest in the outcome means that they can show they are going to be affected by this project. And then the planning board does have the power to permit others to participate as you deem appropriate. And when you're doing your public hearing procedures, I'll remind every land use board under RSA 676:1, every land use board is required, repeat, is required to have written rules of procedure. And I'm just going to read that beautiful little statute. And I'll remind everyone that OPD has an excellent set of suggested rules of procedure for your consideration in the planning board handbook. So again, RSA 676:1 says, every land use board shall adopt rules of procedure concerning the method of conducting its business. And they can be conducted at a regular meeting of the planning board, and they don't require a public hearing. And the statute actually says, once they're adopted, they shall be placed on file with the city or town clerk for public inspection. And maybe you should be sure to have a copy of your rules of procedure sitting on a table, multiple copies, so that people who come in can know how things are going to be running at your particular land use board meeting. So impartially following your rules of procedure, very good and important practice. Site visits are public meetings. So when you conduct a site visit and the public is attending, it's a public meeting. And I know recently we've had a lot of questions where the planning board, typically in your application documentation, this is actually in the planning board statute, the planning board can request that the property owner consent to the entry of planning board members and the public when a site visit takes place. And we've seen a question a number of times in the past. Well, what if the developer is worried about liability? They're going to get sued. We got people crawling over their property. They may fall into some ditch or something. I think, the town is not going to be the insurer of all those untoward, speculated circumstances. But most of the time, when I've done site visits, usually have a couple of butters show up, and you're standing on a driveway talking about a project that the applicant's engineer pulls out a plan and goes over what's going to happen. It's not that intensive, and I don't think it's that much of an intrusion. And it's very informative to planning board members to do site visits. So I think it's a very useful process. On my ZBA, we do site visits, and we site visit every application for zoning relief just to get a better understanding of the property. And in fact, the last time we did a site visit, the reason why we were able to cite specific findings of fact is because we had information that we had gathered from the site visit. And one of the things that we have a form that we use in our ZBA, it's a site plan form, and we list all the people who attended and applicants, engineer, and abutters. We got them all to sign a form indicating they were present. And then at the public meeting, typically we have a site visit for our ZBA applications on the night of the hearing. So we'll have a site visit at 6, and we'll come back to the ZBA hearing room at 7:30. We'll make a report into the record that the site visit was conducted on this day. These people were present. These are the things were discussed. So that would be noted in the record. The last thing I would say about public hearing procedures is if you have the opportunity to access something called Riggins rules, a very helpful way to understand what is your role as a land use board member and how to effectively participate and how to do things which are going to encourage public confidence in the public hearing process. So if you go to Google, and I know that's still on the OPD website, the Riggins rules, which were created by a gentleman who for many years was on the planning commission in the city of Phoenix, are a very, very insightful set of just nuggets of, personal suggestions and information, wisdom garnered for many years on what's an effective way to be a member of a land use board or a public body generally. So you've received the application, you received the documentation, you've heard all the evidence, and now you're at the point you're closing the public hearing. Make sure you get all the information you need before closing the public hearing. You don't have to deliberate and vote at that night. You can continue with another meeting, assuming you have time within 65 days. If you do, continue the matter after closing the public hearing, don't do what the alderman member in the Z1 case did. Don't have ex-party contacts. Don't share information on social media about your point of view until you've made a final decision. The board has the power to rely upon the personal knowledge of the board members of the area in question, part of the reason why you do a site visit. And you're not bound to accept the conclusions of experts, but you generally cannot ignore uncontradicted expert testimony unless the board can adequately explain in a written decision why you don't find the experts were making sound judgments. So just keep that in mind when you're making decisions. As part of the process, the applicant or even abutters had soil scientists, engineers, or others who are providing information. You can say or conclude that an engineer or other experts submitted information is not reliable for various reasons. There was a case not too long ago where our ZBA members had personal knowledge of the traffic activity on a particular road, and even though the applicant's traffic engineer said, "No worries, this proposed use will handle this traffic just fine," one of the ZBA members said, "I don't think so. And by the way, your traffic engineering report was done in May when most of the traffic that we're concerned about often happens in the vacation period, July to August." So there was a specific basis for the ZBA members to conclude the engineer's report was not reliable. It wasn't done at the time period when the most traffic was going to be generated by that particular use. Plus, individual ZBA members had direct evidence about how crowded that road was made during high vacation periods of the calendar. So there can be a basis for a land use board to say an applicant's submission or an engineer's submission or expert submission is not reliable. Also feel it's important to mention the Dartmouth versus Hanover case. And a couple of things probably more important than anything else was to understand the concern the court had with the decision made by the Hanover Planning Board to reject the proposed building that was being constructed consistent with the zoning ordinance. It was a large recreation and training facility that was going to be used for Dartmouth students and athletes. Ultimately, the whole issue came down to that the building was deemed to be too intrusive and was going to cast, because of its height and bulk, a shadow over some of the neighbors who were nearby, a residential neighborhood. And I think a couple of observations the court made in this particular situation was that the Hanover code enforcement officer and zoning enforcement officer had concluded the proposed project complied in every respect with Hanover's regulations. And notwithstanding that, that information being provided to the planning board went ahead and rejected the approval based upon their conclusion that it was, a pig in a poke or a skunk in a garden party. And the court concluded that you just can't make an ad hoc decision which rejects competent engineering evidence and expert evidence, and that rejects the opinions of your own code enforcement staff. So the planning board cannot supplant specific regulations and ordinances that control the site plan review process with their own personal feelings. And so that's something to keep in mind as you're making a decision on maybe a controversial site plan or subdivision plan. So you do have to issue a written notice of decision within 5 business days. And you have to have written reasons, certainly, and as indicated in the HB 1661. If you're going to issue a denial, you have to state not only specific reasons as to why you're saying no, you have to support it with findings of fact. And the statute also requires you to approve, disapprove with conditions, or allows you to approve or disapprove with conditions, or conditions or disapproval. That is, if you're going to approve, you can approve with conditions or you can disapprove. As I've said, you have to have findings of fact, and the decision and meeting minutes must be on file within 5 business days. And a tie vote is not decision. If for some reason you should always have a odd number of planning board members, but for whatever reason, if you only have 8, you have a planning board of 9, and there's only 8 members present. If you vote 4-4 to approve a project and a tie vote is not a decision, you've not made a decision. And you can't say it's disapproved because it was a tie vote. If there's a tie vote, you're going to have to figure out some way to make a decision to approve or disapprove. And you're going to have to cajole your fellow board members ultimately, so you can have a 5-3 decision, or whatever the case may be, approve or disapprove. One thing I would say about written notices of decision in terms of what you are saying, you really can't rely upon your minutes and saying that our decision is based upon what was in our minutes. It really has to be set forth in the written notice of decision. If you have a conditional approval, which 99% of the time when the planning board approves a project, subdivision, or site plan, it's an approval with conditions. Number one, I want to mention, because I've seen this many times in the past, if an applicant makes representation in the minutes that they're going to do something, make it a condition of approval. A representation by the applicant in the minutes is not binding unless you clearly make it a condition of approval. So if they say they're going to put in a small park or a pocket park or a sometimes called a tot lot, where attributes are there for small children to recreate, and all they've done is put that as they've noted that in the proceedings before the planning board, make it a condition of approval. The conditions have to relate to ensuring compliance with your regulations, not necessarily regulations that are regulated, say, for instance, by the Department of Environmental Services, alteration of terrain permits, or things like that. That really has to be your regulatory area that you're going to require conditions of approval. You might have standard conditions. A number of municipalities I've represented in the past had a whole list of standard conditions that were part of every notice of decisions. There's 2 other type of conditions which are important to know. There's conditions precedent and conditions subsequent. What is a condition precedent? The condition precedent is, we will give you final approval once you obtain final engineering review from our engineer for the change you have made on the location of the entrance driveway. If you get a condition precedent like that, you're going to have another public hearing to address that condition precedent, because you can't just allow the engineering report from your town engineer to be received and say, oh, he satisfied that. It contains too much discretionary judgment, and you have to have what's sometimes known as a SCLAR hearing, where you would go over whether or not the engineering review by your engineer of the changed location of the entrance driveway is adequate and sufficient and protects public health, safety, and welfare. Most of the times, condition precedent can be just allowing the planning board chair to go to town hall and sign off on the subdivision or site plan, because yes, they got the permit from the Wetlands Bureau, or yes, they got the permit from alteration of terrain, and it's just a document in the folder. There are, of course, conditions subsequent, and a condition subsequent would be something like, you've approved a site plan, but you've regulated the hours of operation. So let's assume you approved a site plan for McDonald's, and you might say, the outdoor microphone, which is really loud and might disturb the neighbors, has to be turned off, or no outdoor, drive up purchasing of food after 11 o'clock at night, or or hours of operation control like that, or you can't have garbage pickup no earlier than 7 o'clock in the morning, because the big truck with the big dumpster and dropping and noise is disturbing perhaps to neighbors, and that garbage pickup has to be happening after 7 o'clock in the morning. And as I indicated, you might have situations you have to have a compliance hearing whether or not the conditions precedent has been in fact satisfied. Going to try to wind up here right at 10:15. There's an important element, rights that attach to an approved project, and those are vesting rights under RSA 674:39. And there's an important element of that statute the planning boards should take steps to address. Your regulations can define substantial completion of improvements and active and substantial development. So the basic formula of this statute is to say a project, once finally approved and recorded at the Registry of Deeds, I know site plans aren't always recorded at the Registry of Deeds or recorded at Town Hall, are protected from changes in zoning and planning regulations for 5 years automatically, and might get permanent vesting if they're substantially complete. But you need to tell the applicant how much work they must have completed within the first 24 months, or they don't get the 5-year vesting. So it's important to say we expect a certain quantum of work to be commenced within 24 months. That is the active and substantial development. And so I think it's important to address that at the time of plan approval, or maybe even in your regulations, because that helps define what is the degree of vesting rights that particular project will have going forward. So if someone is aggrieved by the decision of the planning board, you now have 2 venues which are available to those who are concerned with what you did and wish to appeal the decision. The first is the Housing Appeals Board. All of you may know very much about the Housing Appeals Board because you've been engaged with the board from your community. The board is there to hear appeals of final decisions of municipal boards, planning boards, on questions of housing and housing development. So it has to include housing or housing development, and then the Housing Appeals Board might have jurisdiction. And a party has the option of appealing to Superior Court or to the Housing Appeals Board. And if they appeal to one, they waive the right to go to the other. And the hearing procedure, and I won't speak to it because I've never appeared before the Housing Appeals Board, I would assume is fairly identical. And it's a procedure whereby the record is the certified record of the planning board's proceedings are reviewed, and oral argument is presented to the Housing Appeals Board. And for the planning board, the key issue is whether there's evidence in the record that supports the planning board's decision. Because the planning board does not have to prove what it did was correct. It's the applicants, the aggrieved parties, whether it's an abutter or the applicant, they have to argue there was something illegal or unreasonable in the planning board's decision. You don't have to prove what you did was correct. All you have to do is prove that your decision is based upon evidence in the record. And there's a much more accelerated process before the Housing Appeals Board. They have to hold a hearing on the merits within 90 days and issue a written decision within 60 days. And the decision of the Housing Appeals Board can be appealed to the New Hampshire Supreme Court. And then, of course, the Superior Court appeal, which is very similar, but the process is a bit more delayed because it takes longer to get the appeal of a planning board member teed up for a final hearing before a Superior Court judge because of the inherent backlog of cases being heard in the Superior Court. But this is the same process. It's a certified record appeal. Based on the certified record, the court is going to probably accept some oral argument or may even just have it submitted on the record with competing motions to affirm or overrule submitted by the applicant or by the planning board, as the case may be. And with that, I would say, bingo, it's 10:14. I have a minute left to answer any questions, but thank you for having me to participate in this Office of Planning and Development Spring Zoning and Planning Conference 2023.
Absolutely. Thank you very much, Steve. As always, your sessions are well attended and produce great questions. So there's been a lot of activity going on in the chat, and we're going to have some good discussions later on in the day for the planner is in the session Q&A. So it is right at 10:15. So thank you very much, everyone, Steve, especially for your time and your volunteering for our annual conference and for all of our participants. There were at one point we had 85 participants in the session and a couple have trailed off here and there, but we're rounding out with 82 participants. So that's wonderful to see such great attendance. And we will break and I will be back with, what am I doing? I'm doing planning board procedures and policies. And that is at 10:30. So we'll take a break, everyone, and we will see you shortly. Thanks, Steve.
Thank you.